Oh,
Never done this before.
I hope it's not dangerous.
Oh, is that? Did I come through there? I didn't come that. Is that key to our key now?
It's okay.
But how did I let it off? How did I set it off?
I do not know.
Because I was sitting, did it go off when I came in? No, I was sitting here when it went off. Anybody approach it? I know.
You want to leave it like that?
Well, I don't want that to happen again, so let's leave it locked and
Keep working
we'll
through it.
troubleshoot.
No problem.
We'll be okay with you guys.
He called me on the radio.
Okay, thank you. I thought this was the system. New building smell. You have the feed you need. I pushed the oral argument button, but I think it had already been pushed. And remind everybody to silence your phone devices. Anything else that will make a noise? All rise. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Judge J. Kelly presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning. Well, this might be a first for many of you. It's certainly a first for me. I'm like, where do I go? Anyway, isn't it beautiful? Beautiful. We're really happy to be here. So welcome, everyone. Our first case this morning. Oh, by the way, housekeeping. Each side gets 20 minutes. If you are the appellant, you can save some of your time for rebuttal. I will keep track of your time and let you know where you're at. And we're ready for our first case this morning. Mathis versus Board of Trustees of the City of Plant City Safety Employees Retirement System.
Yes, Your Honor. My name is Tad Delagal here on behalf of the appellant, Mark Mathis. May it please the court. I would reserve the balance of my time for rebuttal.
All right. I think you mean 5 minutes, right?
5 minutes, yes. Police officers in Florida employed by the state or municipalities are entitled to pensions. Florida statutes entitles them to those pensions. And the statutes set up a system by which they can claim entitlement. The question in this case is whether or not somebody who was employed as a police officer, who was vested with the authority, he was certified by the state of Florida, was entitled to pension time for the period of time in which he was temporarily suspended and for which he was paid to after he returned to employment. And the question is whether there was a factual issue that supported a jury determination as to whether or not he was qualified for a pension for that.
You know, I think I want to stop you right there because that was one of the things I read that gave me pause as I read through the initial brief, is your insistence on this being a factual question as opposed to a legal question pertaining to what the statute and ordinance controlling who's an employee and who participates in the pension plan. Why is this not a legal question as opposed to a factual question?
Well, I think it could have been decided on summary judgment for the appellant for Mark Mathis if there was a question, because I think pension statute should be interpreted liberally. But there are some factual questions here. The questions are, for instance, the defense was, we did not consider Mark Mathis to be a police officer because the police chief had this informal policy of saying that.
Well, he was arrested.
Right.
And then he was indefinitely suspended.
Right.
He was asked to turn in his badge and his gun.
Right.
And the suspension was without pay.
Right. But then
so he couldn't perform any of his duties as a police officer during that time, but he was still employed, correct?
Well, that's not correct.
Okay.
What the record shows is the only reason the police chief says that he could not perform duties, because he acknowledges anyone who is on suspension or administrative leave or vacation leave or sick leave can be recalled, including Mark Mathis. The only reason that the police chief gave as a factual reason that he was not recalled is the police chief's own personal, unwritten, undocumented policy that if there are criminal charges that are being investigated, he would not return somebody to active.
What is the written documented policy with respect to that?
There is none. It is informal, unwritten, undocumented. The police chief's personal.
I mean about as far as being entitled to pension funds, even though you were off duty during that time.
Well, the statute, and the statute says, and it defines when a person is entitled to pension credits, and it deals with the compensation. And the only time that is exempted from compensation under 185.02 sub 6 is the time that is covered by payment of accumulated sick or vacation. Otherwise, compensation for time as a police officer, for service as a police officer, is compensable.
Well, I still don't understand why that's a fact question. Okay, is someone disputing that the chief of police had this unwritten policy? Is that in dispute?
Yes.
They said he doesn't have it? I didn't see that.
I think it's an issue of fact, given the way that other persons were treated.
But this is not a disparate treatment case
No,
against the
it's not.
city.
No, it's not.
So does that really matter? I mean, as there is no dispute that at the time of the suspension, his authority to bear arms and make arrests had also been suspended. So although he generally may have been vested with that authority had been temporarily suspended, correct?
The question of fact is whether that policy actually existed or whether it was, made up after the fact, because.
But my question is, why does that matter? Because again, this isn't a disparate treatment
Right.
action.
Right. The question is whether or not he was really permitted to return to work, whether he could have been employed to make arrest, whether also this was part of his job.
He did receive back pay, correct?
He did receive back pay. And it was reinstated with back pay.
Could we have been let go when the suspension was over?
He could have. And they chose not to. They chose to compensate him as a police officer. And the record shows he was compensated as a police officer.
Well, because of the suspension, if he arguably could have been dismissed at the end of it, how can he be entitled to pension benefit?
Well, because he was compensated, and the statute calls for pension benefits when you are compensated as a police officer. He was compensated as a police officer, and that's in the record. What could have happened is irrelevant. They could have dismissed him without cause. He was an at-will employee, but that's not the issue here. The issue is entitlement.
They accepted him back and not given him the back pay?
They could have, but they chose not to. And that the jury could find that was part of his duties as a police officer, that as a matter.
I think you have a strong argument from the standpoint of, there was a fight, at the end of the day, they didn't find anything wrong.
Right.
That caused the suspension. There was nothing there. It was let go. It was dropped, right?
And they elected to bring him back and pay him back pay.
Well,
but wasn't that kind of in a way, kind of a windfall?
Well,
he might have gotten nothing.
Sure.
But he was brought back and given back pay.
But that's not the issue here. The question is whether or not he's entitled to pension benefits. And he was paid as a police officer. And he's paid as a police officer, he's entitled to pension benefits.
the plan, section 2-526 defines a police officer as an actively employed, full-time, etc. And I don't recall much discussion in either brief about the word actively in the plan. And he definitely, it seems to me, was not actively employed during the time he was suspended.
Well, that raises the issue. Why he was not actively employed. It was the chief of police.
It doesn't matter. The fact is he wasn't.
Well, and neither
The plan definition.
Neither is somebody sitting in a hospital bed after a major surgery who's on sick leave, who can't perform police duties. That person still gets pension benefits. Neither is the police chief.
Does the plan contain a definition for actively?
It does not.
Okay.
So that is why there are factual issues here. Here we have factual issues. We have a police chief who was administratively suspended while he was investigated, received full pension benefits, was not actively performing police duties. I
don't recall that the comparators had been suspended for such an extensive period of time. I think they were just like a matter of days.
Sure.
So presumably during their suspension, this sort of brings me to another question I have. Do we know if they even missed a paycheck? Because where in the regs is the plan permitted to accept a lump sum payment into it? My understanding is deductions are usually made paycheck by paycheck. So where is the provision that allows the plan to accept a lump sum payment to make up for the extensive period of suspension that we had here that's not comparable, I think, to the other cases that were brought up?
Well, I don't know if there's anything in the regs. I know it is routinely done. And I know that is something as a matter of course, when persons pay for back pension benefits. They can, or paid for back pay. They can pay for back pension benefits. And the record is clear that Mark Mathis repeatedly requested the opportunity to do that, repeatedly volunteered to pay for the back pension benefits.
But where is it that the plan is required to accept that offer?
There is a provision, we did not brief, it was not an issue, we briefed it below, but there is a provision that states that that the amount of pension benefits shall be paid, and that the pension is empowered to require the employer to pay those benefits. It's not a discretionary thing. It's nothing that that the employer can elect or elect not to do. Instead, the plan, and I think it's written so that if someone is paid for the period of time in question, he shall also receive the pension benefits. So I believe there is a issue of fact as to whether, given the fact that all these other persons were treated, and I understand this is not a disparate treatment case, and I get your point, Judge. The point is, though, is this a legitimate reason to deny someone pension benefits? The fact that this person, if he was in any other job and they were concerned, we've got a law enforcement agency here who is bound by the rule of law, wants to ensure that its employees are following the law, states our agency is going to put somebody on suspension. And if we find that they haven't violated the law, we're going to reinstate them.
But there was no finding that he hadn't violated the law. My recollection is it was non pros because he had agreed to engage in community service. It wasn't that he had been exonerated. It wasn't as though the charges had been dropped on the merits. And in fact, I think there was evidence in the record saying we had a case against him. We could have gone against him, and we didn't for practical reasons. So doesn't that factor in?
There were contrary statements in the record, yes, but I understand that. And it doesn't factor in because ultimately the employer made the decision to reinstate him. Made the decision, it didn't have to. It made the decision based on the facts and the circumstances and the situation to reinstate this law enforcement officer with full back pay. And based on that, he was paid as a police officer, no question. He maintained the certification as a police officer, no question. He could have been called back in an emergency or any other situation regardless. So the question here is whether or not
he would have had to have been called back and given back his gun and his badge first, right?
Perhaps. I don't know if state law requires you to have a badge at the time that you make police action or you have a gun. I don't believe that's a requirement. I think the police chief at any time could have told Mark Mathis, called Mark Mathis up, and had Mark Mathis enforce traffic laws, arrest suspects, take criminal investigative actions. The police chief chose not to based on personal preferences. And I don't believe those personal preferences are enough to create a rule, a standard, especially in light of the way that other persons were treated.
I want to make sure, you keep saying he was denied pension benefits, but I want to make sure I understand. It's my understanding that he lost 11 months of creditable service.
That's true.
But otherwise, he does have his pension intact. We're fighting over the 11 months of credit for this service.
That's correct.
Ultimately impacts I understand that impacts the amount of the pension. But
Yeah,
he didn't lose his pension entirely.
And that gives a good, that is a good point, Judge. And if you look at the definition for pension credit says continuous service during the time that one is employed.
Actively employed.
Compensation for services rendered. Payments, and it exempts.
Well, that's another point that they've made is that he wasn't compensated for services rendered because he rendered no services during that time.
Well, he stayed at home. He was subject to their directions. He was on suspension. That was a direction. He was under those orders. He remained to be an employee. He was under their regulations, and persons under suspension do remain under the authority. And I would say also the actively, I don't believe appears in the state statute. State statute actually prevails over municipal ordinances. especially under this provision, and there's a good amount of authority to that effect if there's any differences. But the state statute does indicate 185.02.6, compensation or salary remuneration paid by the employer to a police officer for services rendered. And he was paid as a police officer for services rendered. There is no question as to that. And the question only, and if there was summary judgment, it should have been granted to the employee rather than to Mark Mathis rather than the pension. We do believe that we believe there is a factual issue that would prevent summary judgment for the pension, and that is based on whether or not Mark Mathis was indeed paid for services rendered. That's a factual issue. Whether or not
Yeah, I'm still struggling with why these are factual issues and not legal issues that are resolved by the terms of the plan and the statute and the ordinance. That's just, the way I'm looking at it. I don't, if you could clarify for me again, please.
Yes.
What
Well,
do you think, what is the factual dispute to be resolved?
the factual dispute is whether or not someone can be denied, whether there is and I think it gets into the comparison type situation. If someone is sick and unable to work and still given pension credit, is that person still a police officer who is vested with the primary duties for traffic crimes and for traffic offenses and crimes, as opposed to somebody who is able to work, but whose the personal preferences of the police chief prevent the police chief from assigning him duties.
All right, sir, you're at 15 minutes. If you wanted to say 5 for rebuttal, you're free to proceed however you see fit.
And also, I think the factual issues as to whether or not this personal unwritten plan actually did exist. I understand that there is nothing to dispute it, but it is you can't dispute something that someone has just come up with, and there's no reference to it anywhere in writing or otherwise, and hasn't been announced before that time. And actually, also, whether the distinction that the board makes as to persons who are only suspended for short periods of time or put on administrative leave for short periods of time should be entitled to pension credit, whereas persons on longer period of time should not. Does that affect the definition of a police officer? And I would reserve the rest of my time for rebuttal. Thank you.
All right, sir, 4 minutes.
All right, thank you.
Good morning, Your Honors. May it please the court. Stuart Kaufman on behalf of the City of Pine City Public Safety Officers Pension Fund. There are no disputed factual questions at this point in time, and Plant City Board of Trustees is entitled to summary judgment as a matter of law. First, I would just like to point out a statement that was made by my brother during his presentation, that anyone who is suspended is subject to recall. It specifically says in the record, it's a testimony of then Chief McDaniel at 1479 of the record, that anyone who is charged with a crime is not subject to recall. So that is the difference with the comparators. The comparators are also different, as you noted, because they were for a very short period of time. Those individuals would not have missed a paycheck. The pension fund is a defined benefit pension fund. It pays pension benefits to police officers and firefighters for the city of Plant City. But in order to, and it's a contract, there's a case law out there, the Busby case that I cited, and the Bishop case, it says pension is a contract. And the contract is what is set forth in the Florida statutes and what is set forth in the local ordinances. And they're pretty similar. And in order to receive credited service, you have to provide service as a police officer. And the city code provides that it has to be active employment as a police officer. The Florida statute does not contain the word active, but you still need to provide service as a police officer. There is a 3-part test. It's a conjunctive definition of police officer. It requires certification. The The certification standing alone issued by the state does not give the officer anything other than the eligibility to be a police officer somewhere in the state. There still needs to be that operational authority to be a police officer. You have to be hired by a county or a sheriff's office or a municipality and given the authority to make arrests and carry a gun, carry a badge, and your primary responsibility has to be as a police officer. So the definition of police officer, which has not been met here, is that
I have a hard time looking at this and saying he wasn't a police officer. He was a suspended police officer.
he was an indefinitely suspended police officer,
But he was still a police officer.
he was an employee at the time. He was robbed of
So
his
he
ability.
was, well, and your position is he's an employee of the police department, but not a police officer.
He was a police officer in that he was an employee of the police department, is considered a police officer as an employee.
And that's who
But he
has
still does not
control
receive-
over his suspension.
He still does not receive, he's still not a police officer for pension purposes because he does not meet the definition
Well,
of,
I think that's a
police
better
officer
way
in
to
the
put it.
pension.
He wasn't a police officer for pension.
That's
purposes.
correct.
Clearly was still a police.
yes, I
officer.
misspoke. He was a
He
police
was Under
officer
the control of the chief of police who had suspended him. He
and,
was still answerable to that police department.
correct.
Let me ask you, because you mentioned that the word actively was included in the plan, but not the statute. What is the interplay between the plan and the statute, and why wouldn't the plan, you were talking about a contract, why wouldn't the plan control as opposed to the statute?
I think Florida statute would control over the plan, but I don't think there's really any disparity between the definition of police officer set forth in the statute and the
The word actively just jumped out at me.
Yeah, but it also requires, the authority. You have to be, the definition includes the authority. You have to be certified. You have to have
I'm
the-
trying to, as opposed to you're a firefighter or you're a file clerk for the police department. What makes you a police officer? There's certain things that you have the ability to do that you're authorized to do that a file clerk can't do.
Right.
So I'm not all that persuaded by those aspects of the definition.
You have to be vested with the authority to bear arms and make arrests in order to receive credible service on the.
Well, to be a police officer, I mean, your argument is you have to have those things to be a police officer, but we're talking about creditable service.
Right, for services rendered as a police officer, and he was not rendering services as a
Okay,
police
well, that's a
officer
different argument than.
at the time that he was
Police officer.
suspended. Yeah.
That's a different
Yeah,
argument.
he did not meet the
He wasn't
definition.
rendering services is one thing. He wasn't a police officer, to me, is a different argument.
And the testimony is clear as to why there are no undisputed facts. We have in the record the affidavit from former Chief McDaniel, who, although there was not a written policy, he did have the authority pursuant to the city code section 42-34 that says the chief of police shall have the right to suspend any officer or employee of the police force. There's nothing that would require a written policy. He has the authority to suspend somebody and to determine what comes along with that suspension. And his testimony in the affidavit is that Mathis was suspended. He was ordered to surrender his badge and service weapon and did so. He did not provide any services as a police officer during the period of suspension.
Okay, I want to stop you there because that's one of your points and the appellant has focused on this quite a bit. What distinguishes between somebody who's suspended for whatever reason, and let's say there's someone that's out sick, on sick leave for months. Sometimes people are very ill and they're out for months. Where's the distinction? And I understand, I read your brief, the distinction you made in the cases. But explain to me, based on the statute and the terms of the plan and the ordinance, what creates the distinction between those two?
So if the sick leave is really just compensation for services performed as a police officer, it's part of your compensation. It's written into the contract. You're entitled to a certain amount of sick leave and you're entitled to a certain amount of vacation. You do not lose your ability. You're not robbed of
What happens
authority.
if you exhaust your paid sick leave?
What's that?
What happens if you exhaust your paid sick?
Then you don't get paid for that period of time,
And
and
you lose creditable
you would
service
lose
time?
creditable service in that portion. If employee contributions are not made to the pension fund, then credited service in the pension fund cannot be given. And the record is also clear in this case that there was no employee contribution made for the period of time that Mathis was out on suspension.
During that period of time.
What's that?
He wasn't being paid. during
Right,
that period.
and he, right,
Then
correct.
when they did pay him, they wouldn't take a contribution out of it.
Correct. The city did not make the employee contribution, and the pension fund cannot grant credited service without the employee contribution being made. Furthermore.
So that was a determination by the city.
By the city. Well, and the city made the determination not to give him back pay. The reason that he didn't get back pay is the reason that the pension fund found that he was not entitled to credited service. The employee compensation cannot be paid in a lump sum by Mathis either. The contribution has to be paid by payroll deduction, which is provided in the city code. And the reason for that is that it is given a tax sheltered status employee contribution. So the employer has to make the employee contribution through payroll deduction, because it's a provision in the IRS code that in order to be a tax qualified plan, the contribution has to be made through payroll deduction. So if it's not
in a lump sum after reinstating him?
the city could have they didn't have to pay him at all. I mean,
Right,
they did so because they thought it was the correct thing to do. But the employer at that time could have made the contribution for the pension service, but the pension fund really still had the authority to say that that contribution is not for services rendered as a police officer pursuant to the definitions of the plan, and rejected the accredited service in that case. And there have been situations, I've been representing pension funds for 30 years. It's really all I do. There have been situations that have been corrected where a contribution has been made on behalf of the employee, but it was improperly made and the employee was not given credited service for that period of time.
So he was on leave from February 11, 2009 until December 14, 2009. So did anyone attempt to quantify what that means in terms of dollars lost?
The specific amount was not on the payroll form. I don't know specifically what the amount was. The form is in the record itself, and it has the hourly rate of pay, but it does not have the total amount that he was paid, nor does it state that he was paid for any step increases while he was out on the period of suspension.
But we don't know ultimately the dollar amount that the dollar amount to which it affected his ultimate pension payment.
It affected his ultimate pension because in order to be entitled to a permanent benefit from the pension fund, what's called a deferred vested retirement benefit, you have to have 10 years of service as a police officer. And Mr. Mathis only had 9 years and change, so the 10 months would have put him over the finish line in order to be entitled to a retirement benefit down the line when he met the requirements for normal retirement under the terms of the plan. He had to be, I think, probably 55 years old, 20 years of service. He will not get a pension at any time. He would be entitled to a return of his employee contributions. That is what the plan provides.
Okay, I thought the question that I asked the appellant was, did he lose his pension or did he just lose 11 months of creditable service?
He didn't lose his pension. He just never
Never
vested in the right to receive a.
There is no pension for it.
There is a return of contribution, return of employee contributions.
Okay, got it.
Yeah. Just wrapping things up, there are no disputed questions of fact at this time. The record shows that he was indefinitely suspended without pay, did not have his badge, did not have the authority to make arrests, performed no police duties, not subject to recall. The statute is conjunctive in nature. It requires him to have a certification. It requires him to have the authority to have his badge and his service weapon, and the primary responsibility at the time has to be the responsibility for the prevention and detection of time. If there's no further questions, we ask that the judgment below be affirmed.
Thank you.
Briefly on rebuttal, I wanted to address the issue of who determines whether the city pays for the contributions. We briefed this. The ordinance provides that, as well as 112.66, and that was addressed in the Town of Lake Park case, which is in the brief. The pension determines the eligibility and requires the city to make the payments. So that's not an issue in this case. That is based on the pension's determination. It was a good question about the sick leave, because certainly if you have somebody who is unable to perform police duties, that person is not primarily responsible for traffic laws or criminal investigations. That person, though, is eligible for pension credits.
Well, apparently not if they exhaust their paid sick leave.
Well, and that could be, and that's true. If I do not know how that is worked in that situation, and that in that case, Judge, if that pay is exhausted, they are not compensated for time and they're not eligible for pension benefits. But during the time they are on sick leave, they are eligible for pension benefits. Mark Mathis was on administrative leave. He was paid for administrative leave. The pension had the authority to require the city to make the contributions. That's undisputed. The appellees admit that Mark Mathis was a police officer. He was an employee at all times. There is no dispute that he was vested with the authority by the state of Florida to perform the duties of police officer. At the time, though, he was temporarily not permitted by the police chief under an informal policy from making arrest or doing criminal work. He was just in the same same situation as the person sitting in a hospital bed recovering from surgery.
But that's a contractual obligation that the city has undertaken, that if you were entitled to a certain amount of sick leave, you're not assured a certain amount of paid suspension.
I'm not sure of that, Judge. I don't believe that's in the record that there was a contractual obligation. This is an at-will employment. Sick leave is given by the employer, and it's part of a policy of the employer. That is not required. There's no union contract. The city gave that person sick leave to sit in the hospital bed and gave that person pension benefits. Likewise, it is part of their policy to investigate police officers who are suspected of criminal activity. And then once they determine that that person is not going to be criminally prosecuted, to reinstate that person and give that person back pay. That's ever been a part of a legitimate policy, just as it is to give somebody sick pay.
And there was evidence in the record that that was the policy with regard to people who had been suspended for indefinite periods of time?
But it was the policy as applied to this situation. There was no other indication as to why they reinstated Mark Mathis. They didn't have to. It was voluntary. He was an at-will employee. They made the election to do so. And as a matter of policy, returning somebody who is determined to not be criminally.
I'm not sure that one case, a policy makes, but if you have a policy of paying people for sick leave, that obviously that is a practice that,
Sure. I don't know what the case is, but likewise, Judge, one case of policy does not make. All we have in terms of the policy, the alleged policy of the police chief not to recall persons who are under criminal investigation is this one situation, okay? And that is enough to show that there's at least a factual dispute here to support going to a jury verdict. Did that policy actually exist? Is that something that just came up to justify this circumstance? Because it appears that's what it
just come up because maybe they haven't had any other officers that were arrested.
Maybe.
And had pending criminal charges.
Maybe.
I'm not sure I understand why that's important to you.
Well, at this point, it's the question is, was this person considered a police officer? Was employed, who was paid as a police officer, They're saying, well, their justification for not giving them pension credit is we had this super secret policy we never disclosed.
All right, sir, you're at the end of your time.
Thank you.
Thank you both.
Thank you.
Okay, our next case this morning is Holdings JJJ versus Rand.
Good afternoon, Your Honor. May it please the court, my name is Dean Morandi here on behalf of the appellant Holdings JJJ. I'd like to reserve 5 minutes if I may.
All right, sir.
This case arises out of a real property transaction where Holdings JJJ is the seller and Mr. and Mrs. James are the buyers. During the transaction, the parties executed a sales contract and addendum with an arbitration provision in bold, in all capital letters, individually signed by each party. And it states, buyer and seller agree that any dispute arising out of the transaction, sale, contract, or closing associated with this property shall be settled by mandatory binding arbitration in accordance with the arbitration rules of the American Arbitration Association. When the Jameses filed their third-party complaint against Holding JJJ, they had 2 claims. Once that was filed, Holdings JJJ filed a motion to compel arbitration in accordance with that provision. 2 points here. First, whether the case could be arbitrated. So in other words, the arbitrability decision had to be made by the arbitrator, not the trial court. That's error number 1. That actually should be the end of the determination. It should be moved to arbitration at that point. If somehow you get past that, then error number 2 is that the trial court erred in determining that those 2 claims were not subject to arbitration pursuant to this provision. So obviously we'll start with point number 1. And really the case that controls that issue is the Airbnb case out of the Florida Supreme Court. Now, before we get into that, I just wanted to reiterate the standard here. Obviously we're under a de novo standard because we're dealing with a contract. But Florida public policy favors arbitration, and all doubts as to the scope of an arbitration agreement should be resolved in favor of arbitration. We all know that, we understand that, but that guides our overall resolution of this case. So what does the Airbnb case say about this situation? And they repeat it multiple times. I will just go ahead and say, when an agreement incorporates a set of arbitral rules, such as the AAA rules, those rules become part of the agreement, and where those rules specifically empower the arbitrator to resolve questions of arbitrability, incorporation of the rules is sufficient to clearly and unmistakably evidence the party's intent to empower an arbitrator to resolve questions of arbitrability. That's exactly what we have here.
Does every subsection of the AAA rules expressly delegate that decision to the arbitrator?
Every subsection that could have any applicability here.
Well, but we don't know, right? Because it just refers to them generally. It doesn't refer to the specific subsections. And so what Airbnb actually says, consistent with our holding above, incorporation by reference of the AAA rules that expressly delegate arbitrability determinations to an arbitrator, clearly and unmistakably evidences the party's intent. It doesn't say incorporation by reference of the AAA rules, comma, which expressly delegate arbitrability. It doesn't suggest that a general reference to the AAA rules suffices, but it suggested that some specificity is needed, a more specific reference to those rules that do expressly state that. So how does this general reference to the AAA rules satisfy that language in Airbnb?
Because you look at that language and you look at the arbitration provision that is here. It unmistakably incorporates the AAA rules. You can't incorporate the AAA rules without having a particular subset. Now, again, the
But it
language here is
doesn't
broad.
incorporate a particular subset, and a lot of the cases out there, and in Airbnb in particular, they incorporate a specific subset of the rules. So if a specific subset of the rules is not incorporated, can we still say that that particular provision, which is not included in the entire body of the AAA rules, but only in certain subsets, can we still say that that was a clear and unmistakable evidence of the party's intent to empower the arbitrator to resolve questions of arbitrability, when in fact, absent that clear and unmistakable intent, Florida law provides that the court makes that decision?
You can make that determination here because the only evidence in the record is that the subsets that would apply here have that provision empowering the arbitrator with the power to determine arbitrability decisions.
But
That is the
can we say that at
difference
the
here.
time of that the parties agreed to that?
I'm sorry.
But I mean, we can say that now, but can we say that at the time the parties agreed to that?
Yes, because that is the language of this contract. Talking about transaction sale contract of closing associated with this property. All of those things lead to these provisions, these sets of the rules. There has to be a set of rules that applies here. And that set of rules, and the only ones in the records that have any potential applicability here, have that specific provision. So the only way to give effect to the intent of the parties is to look at what set applies. And if that vests power in the arbitrator to make the arbitrability decision, then that is the clear and unmistakable intent of the parties. And that's exactly what we have here. So, and to put an even fine point on it, it is not the linchpin of the issue that you have that specific subset set out in the arbitration provision. And as a matter of fact, we know that because if you look at the Fowling decision itself, that's the decision that the Jameses primarily rely on. That case relied specifically on the reasoning of Nat, which is what was overturned by the Airbnb decision. We know that because they're talking about similar to Nat, and then they reiterate their question before the court, and then adopting the reason of the second district in Nat, coming to the conclusion that they come to. That case was specifically overturned in Airbnb. Now, how do we know that the concern from Fowling was more than just simply whether the specific subset was incorporated in there? We know that because they certified conflict with Glasswall and Guimaraes, the third district decision and fifth district decision. Those two cases set out the specific provisions there. Now, if the only issue was setting out those specific provisions, it wouldn't have been an issue. The Fowling court recognized that the approach to determining arbitrability is broader than simply having to incorporate that provision. And again, Airbnb approved Glasswall and Guimaraes. So we know it's broader than simply the incorporation of that one term. So let me move into the second point, which is, even if you get past that, even if it is the trial court's determination on the arbitrability issue, the two claims brought by the Jameses in their third-party complaint clearly fall under this broad arbitration provision. Now, again, let me take a step back. I said broad. In the Seifert rubric, it would be narrow. But in the plain language, it's more broad. So we're going to use the test, the appropriate test, but this is not simply a case where you're determining the terms of the contract. This, again, I'm reiterating this language, any dispute arising out of the transaction, sale, contract, or closing associated with the property. Very broad in that sense.
Would you agree with me that if it were limited to the contract, you would have a much harder row to hoe here? Or are you hanging your hat, at least in part, on it arising out of the contract?
I think it can certainly arise out of the contract, and I'll go through the two claims to make that even more clear. I think it just makes it even more clear because the arbitration provision is so broad. But it does arise out of the contract. So when we're talking about, in the Seifert rhetoric, when we're talking about narrow, there has to be some direct relation to the terms and provisions of the contract. So let's go over the claims at issue here. The first claim deals with whether the sales contract's legal description of the easement controls or whether the special warranty deed controls. Obviously, you have to look directly at the underlying contract to determine whether that legal description prevails or whether the subsequent special warranty deed prevails. So regardless of the breadth of the arbitration provision, that clearly has a direct relationship to the terms and conditions of the contract, the underlying contract. That would be the sales contract. So let's look at the second claim. The second claim is fraudulent concealment based on the duty to disclose. So what is the duty to disclose? Where the seller of a home knows of facts materially affecting the value of the property which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. Now here's the important part. The seller's duty to disclose emanates from the contractual relationship between the parties. That's the Kelly decision out of the 4th District. It emanates from the contract. So if that is not enough on its own, the defense to this comes in part from Section 2 of the addendum, which is the underlying controlling contract. That establishes that the Jameses conducted an inspection of the property and were aware of its relevant conditions. Again, the claim itself comes from the contract. The defense itself comes from the contract. You have to determine whether those terms and conditions apply to their claim of a breach of the duty to disclose, that underlying issue.
Well, the way that their complaint is drafted, I think very carefully does not make reference to the contract at all in connection with counts 1 and 6. So should that be a consideration?
Well, absolutely not. The cases abound saying that artful pleading won't get around what the actual crux of the claims are. I think obviously potentially they did that to avoid arbitration, but you can't get around that those claims emanate from the underlying contract. And certainly,
is that enough? I mean, the case law is not very helpful in quantifying the distinction between a substantial relationship and a direct relationship. So help me understand why under this narrow language of the clause, I mean, I think if you had to show a substantial relationship, then just saying we're going to have to refer to the contract, it's, you know, that'll get you there. But explain to me why that's enough to be a direct relationship.
the contract controls. Let's talk about the fraudulent concealment claim. The duty arises from the contract. The contours of that duty are based on that contract. You cannot decide that claim without reference to, determination of, consideration of, and determining the scope of the provisions in that contract. Again,
why can't they just come in and say, we wouldn't have even gotten to the contract but for this fraudulent misrepresentation? The claim does not arise out of the contract arose out of the misrepresentation.
because Section 2 of the addendum nullifies that, it falsifies that, well, not falsify. Section 2 of the addendum says, you looked at everything, you're aware of everything on the property, and you're moving forward with that. So you can't come back and say, well, whoa, I never would have gotten to that. I wouldn't even made that representation if I knew about this. It's kind of a chicken and egg thing, but they have represented in this contract that they were inspected the property and aware of its relevant conditions. So by doing so, they've put this into the contract. They're arguing against an express provision that they signed. Obviously, they're going to dispute that, but this is the defense here. You have to go to the contract to be able to determine the scope of that. And the scope of section 2 of the addendum is going to determine how that defense is presented to the court. So yeah, I mean, if they wanted to present this claim, yes, they can artfully plead it to avoid bringing in the contract, but they can't avoid the reality of the contract being controlling here. And the contract is the document that has to be construed. So that means there is a direct relationship to the underlying contract here. I think taking a look at the cases that they cite for their proposition actually helps us here, right? So we take a look at the Citigroup case. That was a former WorldCom employee, had stock in WorldCom. And in doing so, they had an account agreement. That account agreement has a arbitration provision, right? So sometime later, the opinion doesn't specify, the employee went to an analyst, said, you know, should I diversify? The analyst said, no, things are going great. Well, they didn't go great. And then at that point, the plaintiff filed all kinds of claims. In that instance, it's clear to see how the terms of that account agreement have nothing to do with. There's no direct relationship to the claims that are brought. We have nothing like that here. Those claims, in this case, emanate directly from the underlying contract.
You were at 15 minutes, sir.
Perfect, Your Honor.
How you doing?
I'll just talk about Miller very quickly. The other case that they rely on is Miller from the 5th District. Just look at the arbitration provision there. In the event of disputes between the parties with respect to the terms of the agreement, we have a much broader, again, I need to use a different synonym than broad because we're talking about narrow under Seaford. But here we're talking about out of the transaction, sale, contract, or closing associated with this property. That's simply not the case here. And also in that situation, you read the facts, it has no direct relationship to the contract, unlike the situation here. And I'd like to save the remainder of the time. Thank you.
May it please the court, my name is Nicole Pote and I'm an attorney with Lewis, Longman & Walker, and I'm here today on behalf of the appellees, Mr. Robert and Ms. Luceline James. Today, your honors, we request the court uphold the circuit court order denying Holdings JJJ motion to compel arbitration. And I'd like to start with the first issue on appeal. And with respect to that first issue on appeal, the trial court and not an arbitrator properly decided the question of arbitrability because the arbitration clause at issue in this case does not clearly and unmistakably delegate that threshold question. Appellant made reference to evidence in the record of applicable rules that could apply. And I want to address that point up front. Appellant's reference to the evidence in the record, those rules that were put into the record were put into the record by the appellant. There is no reference in the contract to the consumer rules, to the commercial rules, or to the construction law rules. And so when you look to those rules, while you may find that they designate the question of arbitrability to the arbitrator, they also contain specific requirements for them to apply. And with respect to the consumer, and that's critical because it's a critical distinction because it's not clear which subset of AAA rules should apply in our case. And when we look at the consumer rules, they expressly state that a real estate contract and not a consumer agreement, a real estate contract is not a consumer agreement. And they list out specific requirements that must be included in the contract. And those requirements are not met by our contract, and those requirements are set forth in appellant's appendix at page 308. So even if the consumer rules were to apply, when you get to if it went to an arbitrator, it would quickly be returned because the contract doesn't satisfy those conditions. And the same can be said for the commercial AAA rules, in that if there isn't a specific subset designated, those rules only apply to domestic commercial disputes. That's not what we have here. We have a real estate contract. The same can be said about the construction rules, which again, if that construction rule subset isn't specifically identified, we would have to fall under a construction dispute. And that is simply not where we are with this contract. This contract is for the purchase and sale of real estate. There are real estate AAA rules that in appellant's briefing they call defunct. There's no record evidence to support that they're defunct. When you go to the website to see those rules, they're archived. So what does that mean? It's not clear. And I think that raises the overarching issue on this point, is that there is an ambiguity in the contract as to which subset applies. So because of that ambiguity, there is not clear and unmistakable evidence of an intent to designate the question of arbitrability to the arbitrator. Turning to the Florida Supreme Court decision in Airbnb versus Doe, Airbnb acts as a guide to what constitutes clear and unmistakable evidence of intent to delegate the threshold issue of arbitrability to an arbitrator. And it relies on the standards set forth by the US Supreme Court in First Options of Chicago versus Kaplan. And appellants misapprehend the holding at Airbnb and rely on an overly broad reading of that holding to suggest that any reference to the AAA rules designate the threshold question of arbitrability to the arbitrator. That's not an appropriate reading of Airbnb. For starters, Airbnb, when it speaks to the AAA rules, it actually, in the opinion, it defines what those rules are. And in that case, it is the commercial arbitration rules and supplementary procedures for consumer-related disputes. And those have an express delegation of the question of arbitrability to the arbitrator. Our contract is not, it's like comparing apples and oranges. The arbitration provision in the Airbnb decision is entirely distinguishable from the arbitration provision that we have in our case. Our case is more like fouling, and the fouling decision was not specifically overturned by the US Supreme Court. And while it makes reference to reasoning in the Doe versus Nat case that was specifically overturned, these cases rely on the First Options decision, which requires clear and unmistakable evidence of an intent to designate the issue of arbitrability to the arbitrator. And in our case, there is not that clear and unmistakable intent. And as such, we revert back to the Florida statutory requirement that a judge and not an arbitrator determine the issue of arbitrability. Turning to the second issue on appeal, the third-party claims here are not arbitrable under the arbitration clause's narrow scope. Appellants made reference to sort of this idea of a narrow plus standard. That narrow plus standard doesn't exist in the case law. And it's an important distinction that our contract at issue deals with a narrow provision because that changes the scope of the claims that may be subject to arbitration and the test that the court applies.
Well, let me stop you there, because it requires that the claim arise out of something and that it have a direct relationship with something. And if all we were looking at was the contract, I think you would have a stronger argument, but I am having a hard time seeing how the claim that you were misled into entering into the contract is not a dispute arising out of and having a direct relationship with the transaction or the sale, certainly, either one of those. So can you, if we were stuck just with the contract, I'd say, I think you got something there, but explain to me how that doesn't have a direct relationship and arise out of the transaction and the sale.
I think that line of thought goes to this idea that but for the contract, there wouldn't be the claims at issue. And so to answer your,
It's not just the contract, and it's not just but for causation. It's the proximate cause. I mean, we wouldn't have entered into the sale but for the misrepresentation. How is that not a direct relationship between the misrepresentation and the sale?
well, Your Honor, it's not.
It's misrepresentation that came out during the transaction.
And Your Honor, I would argue that it did not.
I understand that, but why?
This fraud in the inducement claim, the duty to disclose applies to potential buyers as well. And that's why it doesn't arise out of, and it doesn't have a direct relationship to the contract. The fraud happened before the contract was entered into. The fraud.
We're still going back to the contract. And it is broader in the sense that it encompasses claims arising out of the transaction and sale. So at what point does the duty to disclose arise? I mean, if you go look at a house, the minute you walk in the door, they don't have to say, hey, just want to let you know. So at what point does that duty arise? And how is that not part of the transaction, at the least?
Your Honor, I would suggest that the Johnson v. Davis case supports a theory that the duty starts if at any time you have knowledge of an unknown, if you have any knowledge of a known defect, that you have a duty to put potential buyers on notice of that. And that duty is to the general public, that you're not selling property that has some sort of, issue with it. And so in the instant case, not only does the case law for a narrow provision support the fact that fraud claims generally don't fall under it unless there's a direct relationship, the fraud claim at issue here, the fraud and the inducement with respect to the severed drain field, that happened before the contract, before the transaction, before the sale, before the closing, and it continued after. So based on
the transaction defined anywhere else in the agreement?
I do not believe so, Your Honor.
Its ordinary meaning.
Yes, Your Honor. You would interpret it based on its ordinary meaning. And I want to make a reference to appellant's argument that the clause is technically narrow, but its language makes it broad enough to capture everything inextricably intertwined with the transaction, sale, contract, or closing associated with the property. And again, that's not the controlling inquiry. Instead, the court must ask whether the dispute bears the requisite direct relationship to the contract performance. And in this case, we maintain that it simply It simply does not. And the Jackson case that's relied on heavily by the appellants in making that argument is distinguishable from our case because Jackson dealt with a broad arbitration provision that included that relating to language. And the Jackson court reaches the conclusion that the fraud claim has a significant relationship to the contract. And we don't have that significant relationship here. And we don't have to meet that standard here because it's a direct relationship standard. And I'll also emphasize again that the separate case provides that narrow arbitration provisions, such as the one at issue, don't pull in these kinds of tort claims. And so the trial court appropriately determined that those counts and claims are not subject to arbitration. So just to summarize, there's no clear and unmistakable evidence of intent to delegate the question of arbitrability to the arbitrator. The narrow arbitration provision's mere reference to the AAA rules is not sufficient, and that is supported by the holding in the Florida Supreme Court Airbnb case, and it's supported by the Fallon case, which remains good law. And to the second point, the James's declaratory judgment and fraudulent concealment claims do not bear the required direct relationship to performance under the contract. With respect to the declaratory judgment claim, that was a unilateral action taken after the closing. So it can't possibly arise from the transaction, sale, contract, or closing because it happened after. And so again, I'll maintain on that point that that's not enough to fall under the direct relationship test. And as such, Your Honors, we respectfully ask the court to affirm the trial court's order denying the motion to compel arbitration.
Thank you.
Please, the court. Just a couple comments. I just want to reiterate a point on the arbitrability issue. When you have expressly incorporated the AAA rules like we have here, you have necessarily incorporated one of the underlying sets of rules. And frankly, if you go back and look at the record, there's no indication the trial court undertook any kind of analysis to determine which set of rules apply here, which is something that would have to occur in this situation. And if, as we suggest, that the only potential rules that could apply here have the arbitrability provision where the power is vested in the arbitrator, then the arbitrator is the one that needs to make that decision. And that's what the record here supports. So moving into the issue of if the trial court had the authority to determine whether these claims fall under the arbitration provision, I think Your Honor hit that on the head in terms of you're talking about arising out of the transaction, sale, contract, or closing associated with this property. I maintain that it could be out of the contract itself, but certainly if you're looking at the transaction, if you're looking at the sale, the allegations of the complaint, regardless of whether they try to avoid the contract, however they try to draft it, it falls under that provision directly. There's really no way around it in this, and you cannot ignore the plain language. Even if this is considered a narrow provision under Seaford, you can't ignore that language just because it has arising under and doesn't have arising under or related to. That doesn't mean you get to ignore the remainder of the provision. And the remainder of the provision is, again, broad outside of the Seaford sense, broad in a plain language sense that still has to be applied in this circumstance here. You also heard counsel, as they said in the briefs, suggest that this duty, the duty to disclose, somehow arises in common law. Well, I don't believe that that works under a common sense interpretation of what that duty to disclose is, but it's also against the case law. If you look at the Kelly decision, as we said before, and I quoted it before, the seller's duty to disclose emanates from the contractual relationship from the parties. If it didn't arise at the time of contracting, it certainly arose during the transaction, certainly arose during the sale, and I believe also through the contract. So clearly that arises and falls under that arbitration provision here. There is no general duty to the public, in the case they cite for that, don't stand for that proposition. In fact, they talk about the Johnson case. And again, I cited the Kelly case from the 4th District. That actually cites the Johnson case. That language about what the duty to disclose is comes from the Johnson case. And then the Kelly case puts the point on it and says the seller's duty to disclose emanates from the contractual relationship between the parties. And clearly, from the plain language of this arbitration provision, it falls under that.
Count one. Let's go back to count
Let's
one.
go back to-
Correct.
absolutely.
Obviously, it's related, but what is it that makes it a direct relationship?
Again, it has to do with how it's framed. Obviously, the Jameses are going to suggest, oh, it was a unilateral action that happened later that must be that just ignored. You don't even have to look at the contract. Just as in the other count, in this case, Holdings JJJ's position is you look at the contract, you interpret the contract, the provisions of the contract, the legal description as it appears in the contract, and you determine whether that was appropriate. Our position, it was not.
Disputing that's not in there, right? I mean, there's not a question that the easement was conveyed as part of the contract. That's not part of the dispute, right?
It is. It is. That is the dispute.
Correction, if, right, after the fact.
Our position is that legal description is incorrect. It's part of, again, let's get out of the contract and let's talk about the transaction. As part of that transaction, there was an ingress and egress easement, but not as captured in that language of the legal description in the sales contract itself. And that's the defense to their position. Simply because they can litigate their case without looking at the transaction and without trying to look at the contract doesn't mean that the defense is handcuffed. The defense obviously is going to look at the transaction, directly at the contract.
So you would equate direct relationship with something like essential to the resolution. That sort of would be your equivalent. Is that?
I mean, I think that's fair. It's certainly essential to the resolution, but you are going to be interpreting those provisions. You are going to be interpreting the intent of the parties in that transaction and the intent of the parties in that contract. That answers the court's questions.
All right, and that concludes your time.
Thank you very much, Your Honor. Obviously, we respectfully request that the court reverse and remand on this issue.
Thank you. Thank you both. Next this morning, we've got Doe versus YMCA. Morning.
Good morning.
Whenever you're ready.
Your pen. May it please the court. My name is Brad Bell. I am co-counsel for the petitioners John and Janet Doe. With me at the table today is Peter Andrews, counsel for the petitioners. I'd like to reserve 5 minutes
You got it.
Thank you. We're seeking a petition, or pardon, we're seeking a writ of certiorari to preclude, or at least at this stage of the litigation, preclude the multi-hour psychiatric medical examination of Jane Doe. Jane Doe was 3 years old at the time that she was sexually assaulted by two older boys, ages 7 and 11, in the jungle gym area of the kids zone of the YMCA. Jane Doe is now 8 years old. We believe the trial court departed from the essential requirements of law in three primary ways. The court improperly shifted the burden to the plaintiffs to refute the necessity of the compulsory medical examination. We believe the case law is clear that it is the movant's obligation to put on evidence through an evidentiary hearing, affidavits, or sworn testimony establishing the necessity of the testing. The YMCA failed to provide any evidence regarding the necessity of the particular testing or why any of the tests were relevant or necessary.
Counsel, this is a difficult case, very unfortunate to say the least. But what else can they do in order to figure out how this child is doing at this point? Aren't they entitled to have professional do an examination?
Yes, I agree that the damages to the child are clearly psychological damages.
I mean, that's the whole case, right?
It is. This is not a physical damages case. This is a psychological damages case. It is our position, though, that the defendants in this case have failed to show good cause for these tests. I mean, what we have is, and it was attached as Exhibit B to their motion to compel, and it is 183 of the appendix. And it is literally a list of tests. It's a list of 12 tests. There's no good cause shown as to why any of these particular tests are necessary. There hasn't been any discovery done of her providers over the last 5 years. I mean, this is, I mean, when I add up the tests, it's just shy of 4 hours of testing for a third grader. And that doesn't include everything else. I mean, when I look at the Exhibit B, it starts with clinical interview with the child and parents to obtain relevant background history, developmental, educational, interpersonal, medical, mental health, etc. How long is that one going to take? She's been in therapy for the last 5 years. I mean, this is going to be an all day, much longer than a day of school for this third grader. So what we believe, where we believe the trial court departed from the essential requirements of law was shifting the burden back to the parents. We filed a motion for protective order. We said they have not shown good cause for these tests. The trial court denied our motion for protective order, and the trial court granted their motion to compel.
So is your position that they were required for every single test to present some sort of testimony about what this test entails and tests for, and why that particular thing is relevant to which particular claim?
Yes, and we believe that Russenberger requires that. Russenberger specifically states that it is the burden of the movement to show good cause as to why each examination, good cause for why each examination is necessary. And that just simply wasn't done here. As we stated in our brief, and if you go to the first one is the mini mental state examination, the MMSE. There's no explanation what it is. Again, this is 183 of the appendix. They claim that it's 5 minutes. When we look it up, it states it's a 5 to 10 minute assessment of mental status in hospitalized patients. It is considered the most widely used test for standardized cognitive assessment in the clinical setting, especially with the elderly population. How does that burden revert back to the plaintiffs, the parents here, to say, wait, this isn't, there's no good cause here. This isn't nobody has shown that this is medically necessary. Why are we supposed to guess why their doctors want these specific tests? I think that only half.
The second amended complaint lays out the claim, the reason for the claim, does it not?
We allege damages in our complaint, certainly.
Right.
Mental and psychological damages, yes. But that alone cannot carte blanche allow a battery of tests of an 8-year-old girl. There has to be, every safeguard should be applied here. She's been in therapy for the last 5 years. The risk of re-traumatization is real. And to just say, well, you put your mental acuity and emotional stability at issue, so we're going to allow a battery of tests on this child. I mean, are we supposed to just pack a lunchbox and let them test her for 8 hours? I mean, that is not what's required in Russenberger, and which is a Florida Supreme Court case. I understand the case law that, that is being cited by the other side, that, the in controversy and good cause can be established through the pleadings. But that's only part of the way. I mean, that's citing to Schlossenhoff, which is a 1964 United States Supreme Court case. Russenberger is 30 years later, 94, and it's stating that the requirement is that you have to show good cause for each test. I mean, of course, words matter, and I mean, if we get into the details of.
After the judge ruled on the motion to compel, was there any back and forth between the parties about the scope of the examination, or any discussion about it, any testimony about it?
Counsel, yes, we did discuss back and forth regarding it, and I want to say our comments.
Just to be clear, are you objecting to any kind of examination whatsoever, or is some of these different tests acceptable in your view?
Well, I think if they actually sustain their burden, and they do via, as required under Russenberger, they do via affidavit or evidentiary hearing, etc., establish that these are necessary, explain to us why they believe these are necessary. We can counter that via affidavit or in an evidentiary hearing, and then the judge makes that determination. We agree the judge has wide latitude in making the determination as to a compulsory medical examination, but there needs to be that sworn testimony first. So
can you point to me in Russenberger where that level of specificity is required before the test can be ordered? I'm going back through it and having a hard time. That basically requires the trial judge to evaluate every individual requested test to determine whether it's appropriate, as opposed to more generally whether the allegations or the evidence, and I say allegations in this case because it is the plaintiff's case, would show the need for a psychological examination.
So in Russenberger, I'd like to start with, as I was saying, because words matter, and Russenberger does cite to 1.360, and subsection 2, an examination under this rule is authorized only when the party submitting the request has good cause for the examination, not unexamination. So I think that is specific. I don't think it is general. So, and then Russenberger does go on to state that several things so this would be under heading 3, I don't know how yours is formatted, so I don't want to go by, but while judges should and do have great discretion over whether to order a psychological evaluation, that decision must balance the potential harm and privacy interests of the child against the potential benefit of an evaluation. The evaluation may subject a child to a battery of tests and extensive interviews that could negatively impact and traumatize the child. That was what I was referring to earlier. So
We're looking at the transcript from the hearing, the May 1, 2025 hearing before Judge Hamilton. The judge points out that the claim consists of the damages in the life of the child Jane Doe has suffered and will continue to suffer bodily and mental injury, pain and suffering, disability, disfigurement, emotional distress, psychological and psychiatric trauma, mental anguish, humiliation, confusion, embarrassment, loss of self-esteem, loss of dignity, loss of capacity to enjoy life, invasion of privacy, et cetera, et cetera. I mean, it's a pretty comprehensive list of claims.
yes,
That is being attempted to be met, rebutted, what have you, by expert testimony. I don't know how else they would do it.
and again, I'm not saying that after a proper hearing regarding the testing, regarding the requested testing, that some, or I don't know, maybe even all of these tests, I doubt it, but may be appropriate. We just haven't gotten there yet. I don't think the case law, and I don't think Russenberger can be interpreted as, okay, you put it at issue and now the gate is open and you get to test for anything and everything. There has to be some guardrails associated with it. And you know, of course, this case does cite Judge Lawson-Hoff, as most of the cases do, because Lawson-Hoff is cited in the committee notes to Rule 1.360. But even in Lawson-Hoff, it states that, you know, the court should look at other less intrusive means to obtain the information. And again, none of her treaters have been deposed. There hasn't been any discovery of them at all. I mean, this is going to be in a vacuum if and when they do these tests to this little girl. She's not going to be able to explain how she felt when she was 3 years old when this happened. Her changes versus, you know, in her personality as opposed to, you know, what someone else. She's 8. She's in 3rd grade. There are so many different ways, and I'm not saying that the defense is not entitled to defend their case and try their case, how they're going to handle their case. But we are talking about an 8-year-old girl that was sexually assaulted when she was 3. And to not have any guardrails on this.
I thought that was the purpose for this hearing, to talk about what the examination was to consist of and whether there would be an entitlement to, where would these guardrails be?
There is where they should have come into play, Your Honor. I completely agree, and it was their burden to
As
show.
far as more specifics, that's what your argument is?
Yes, they had the burden via sworn testimony or affidavits or evidentiary hearing to establish good cause for these. It didn't happen. Instead, the trial judge kicked that burden onto us and said, you haven't established that she's going to be harmed as a result of these tests. Motion, our protective order denied, and the motion to compel the examination forward. And shifting that burden to us was completely improper. So that is the primary issue. I'm not saying that they're not going to ultimately be entitled, but the proper steps have to be taken. I mean, there was no balancing, as I just read regarding Russenberger, as far as the potential impact to this child. And, you know, Russenberger was dealing with a divorce case.
I want to let you know, sir, you're at 15 minutes.
Thank you. Russenberger was dealing with a divorce case. I mean, we're dealing with something that, quite frankly, she's been trying to overcome for the last 5 years. So
I'll reserve my time. Thank you.
Please the court, Diana Stein on behalf of the respondents, YMCA, Mr. Cortez and Ms. Penn. And to be clear, the plaintiffs in this case are claiming extraordinary damages, all psychiatric, mental in origin. The complaint, the allegations were read from the transcript. The motion to compel says that the child, who by the way is now, I think, close to 10, she's 9 now, isn't the same child anymore, et cetera. That the parents have tried to bring damages claims of their own. Those were dismissed, but they're pending on appeal. So these are extraordinary claims for damages. And the plaintiff's position has been a bit of a moving target, but they seem to be saying either that we can't get their experts can come in and talk about their examinations of the child, but we have to do more to do the same. So let me talk about some of the things that were just discussed by my colleague and the court. And it's our position, first and foremost, that they haven't identified departure from the essential requirements of law, and that's why we're here. In fact, when counsel read from the Rutzenberger decision, and he mentioned the great discretion that the courts have, this is exactly where this court was. The requirements of the rule were complied with, and that was all that needed to be done. The rest was in the hands of the court. So let me start with just the law. There's the Schlagenhoff case, which the rule was designed not to conflict with, which says clearly that when these types of damages are pled, they're at issue and good cause is shown. Now, Rule 1.360 has an additional protection for plaintiffs, for all people who are going to be compelled for exams, and that is the parameters, the time, place, manner, person who's doing the test, all of that has to be provided in the motion to compel or in the notice or in advance. That was done, and the court acknowledged at the hearing that she read them, and plaintiffs keep talking about this as an 8-hour test. They said that at the hearing. The testing of the child themselves, I counted from about 2.25 hours to 3.5. But more importantly, and to respond to Judge Black's comment about the back and forth, there absolutely was back and forth here. The defense requested the CME. This is a year ago now. I think it was June of 2024, and or perhaps, yeah, I think it was 2024. That the plaintiff said, we can't agree at this time, but we're going to have our expert look at these tests and decide whether more protections are necessary. Once that was done, you know, here are the parameters. The defense wrote back and said, what does your expert say? And the response was, you know, we don't agree to it. The defense wrote back and said, feel free to tell us why. Now, it was in January that the motion to compel was filed, and the defense's motion said, we still don't know what we're supposed to say. Here are the parameters. We've done everything we want. We don't know what else is needed. The plaintiffs never came back with any evidence. They talk about an evidentiary hearing here and there. An evidentiary hearing requires proffered evidence. No evidence has ever been proffered to the trial court. They came back with their own unsworn allegations, and I'm not sure if it's just, you know, counsel's Googling of these tests, but they had an expert, and the expert, for whatever reason, wasn't willing or didn't put in an affidavit anything wrong with these tests. So to the extent—
Let me ask you, because
Yes,
I
Your
think
Honor.
you're doing a nice job of recounting everything that happened. But for me, sort of what this comes down to is you all had the burden of establishing good cause for the examination. Is potential harm to the child part of good cause for the examination? Is whether every individual test is targeted to a particular, I mean, what constitutes good cause for the examination? And at what point was their burden triggered to come forward and say, you can't do that, or you shouldn't do that, or this one's okay and that one's not, because they're suggesting the entire burden was on you to come forward and say, we want to do this test and this is going to be okay because the child, you know, it relates to this and there's not going to be any harm. So I'm trying to figure out, when does your burden end and when is it their burden to come forward?
Absolutely, and I'm going to start with the Russenberger case because it was discussed a lot. That deals with non-party examinees, so that is just not part of this analysis at all. The burdens are laid out pretty nicely in the Florida Emergency Physicians and Dominique case, and that says that the compliance with it starts with the compliance with the rule under the Schlagenhoff case, and that is, you go to the pleadings. If we're talking about a plaintiff, you go to the pleadings and you first see what conditions at issue. That's what these cases seem to say, that you have to show that each condition being tested is at issue. So we can't ask for a brain MRI without showing that, you know, perhaps there's a physical issue. So the psychology is at issue. We've shown that. Schlagenhoff also says good cause is shown by the pleadings, but the rule says you've got to do more. You've got to show time, place, and manner parameters, which we did. That is where the burden shifts. And the reason for that is, first of all, there's not a case in Florida that says otherwise when we're dealing with a litigant who's put this injury or condition at issue. But number two, plaintiff would have, because they haven't suggested a rule as to when this applies, they would have this apply in every single case, because that's what the rule is that they're advocating for, is that whether it's a broken leg or a bad back or a psychological exam, the defense, without knowing the objections, has to just anticipate what the objections may be, have a full evidentiary process, and then still be subject to whatever plaintiffs are going to come up with at the hearing, which is essentially what happened. So to Your Honor's question about the consideration of the age of the child, that's, I submit, on them. And what the defense did say here is that, and the court took this into consideration, she said it at the hearing, she's already being treated by treaters. She's going through treatment. So at this point, plaintiff has to come up with an affidavit. They had 10 months to do it, to say this is either unnecessary, it's overburdensome, it's going to harm the child. And that is where I would say that the cases say that where the burden shifts in every case. If we're dealing with a non-party examinee, it may be a different story. And I do think under Russenberger, that may be the case, but if we've already crossed that threshold easily by the complaint and their motion for protective order. Aside from that, I mean, just to go through this, you know, the risk of re-traumatization, you know, how is the defense supposed to know? Again, they have to come in and say that. They could have done so much more here, but what they gave, they've just, if you read their motion for protective order, it seemed to be saying it's just unconscionable to test a child. But we presented, Your Honor, with cases saying children are subject to the same rule. The only difference in the rule is their parents are allowed to be present, which our parameters say they are. But other than that, they are subject to the rule if they're bringing claims. And so the defense complied with every part of that. Those are the guardrails. The guardrails that plaintiffs' counsel are talking about are the parameters of the rule and showing the parameters of the tests, which we did. They could have responded with evidence. They didn't. So I would submit there has been no essential requirements of law that plaintiff can point to that were violated. This is 100% within the discretion of the trial court, and it was a good decision by the court given the level of damages the plaintiffs are contending they would like to recover. So I would submit that this petition for writ of certiorari be dismissed or denied. Thank you.
Thank you.
Thank you. A couple of responses. First, I went back through Russenberger, and the portion of Russenberger is the citation to Schlegelhoff. And Schlegenhoff, it specifically states that in controversy and good cause, and this is footnote 4 in Russenberger, are not met by mere conclusory allegations of the pleadings, nor by mere relevance to the case, but require an affirmative showing by the movement that each condition as to which the examination is sought is really and genuinely in controversy, and that good cause exists for ordering each particular examination. The argument that was just made by counsel was, well, this was where the burden shifted. The burden shifted because we did not come forward with evidence. There's no case law that says that. The case law is that the burden is on the one trying to compel. So the requirement by the defense for these particular tests was to at least more than just a list of 12 tests. This is why these tests are necessary. They obtained this list of tests from their expert that was going to be providing them. How is it more difficult to actually tell us why they're necessary via affidavit? If we're looking at these tests, like the one that I read, it's primarily for people in hospitals and elderly. So the argument is that my side needs to try and interpret why this may or may not be necessary, and then make an argument via affidavit or otherwise, for them to then turn around and go, no, that isn't what we were going to use it for anyway. We were going to use it because we use it off brand for this, that, and the other. We're not the ones in that position. They are the ones that are asking for this testing. They are the ones that know why they're asking for it. We then get to defend it. There's no case that I have found. There's none that have been cited. And the rule specifically says it is the burden of the movement to show why the examination is necessary. That was not done here. Simply providing a list of 12 tests to have this little girl submit herself to testing for the day, because it's not 3.5 hours. There are all sorts of explanations of what you need to do for this test, the time in between the tests. There's going to be a lunch break. There's this whole clinical analysis in the beginning. This is a full day. And Exhibit B attached to their motion to compel does not meet their burden. The reversible error here is shifting.
Departure from the essential requirements of law.
Yes, I'm sorry. The departure from the essential requirements of law here was the trial court shifting that burden to us. And there was no basis for it.
Thank you. Good. Okay, next this morning, we've got Evans. Yes, whenever you're ready. I'm sorry.
No,
Here.
my fault. I just want to make sure. May it please the court, my name is Brian Lee. I'm representing Teresa Evans in this appeal. I'd like to reserve 5 minutes of my time for a little. So this case comes to the court from a summary judgment that was entered by the trial court, where the trial court, as well as now appellee in this case, is saying that the condition in Mannheim's parking lot and it's obvious, it's ordinary, it's innocuous, it's not dangerous. All these things were sort of lumped together within the trial court's order as well as in the appeal. We believe that the trial court committed error in doing so for multiple reasons. And the facts of this case show that none of those are correct. And so when we look at the facts of this case, I want to start from the actual condition itself. There's pictures and we know what it looks like. It's actually pretty rare that we have in these kinds of cases the actual condition of how it was. There's no dispute as to the condition as it was on the date that Evans tripped on it, because that was pretty established. We know that that condition is on the parking lot or the property of Mannheim, which as we know from the briefing, is an auto auctioneer place where literally the parking lots where these cars are kept it's almost like their showroom. That is the property, that is the business that they do. And so when Miss Evans and her husband came to that area, they came through the security gate. They got told where their vehicles were. They were there to pick up, and they started walking towards it. I did want to mention one thing, and there's arguments in the answer brief about this sort of concept that, well, we've got acres, and this is Mannheim talking, we've got acres and acres of property. How can we look at all this property? How can we be responsible for that? Well, number one, it is your property. So frankly, I think my argument would be the same whether it was on acre 5 of it or versus acre 1. But we know that the facts of this case are that this particular condition was about 100 feet, give or take, right after the guard gate.
Well, we don't know what the discrepancy in elevation is, do we?
We don't. We don't know specific inches. Certainly, and I've looked back at the record, and they're very correct. There's no expert testimony that says, you know, this elevation was 3 inches versus 4 inches. And so, whereas if there was that testimony, yes, we'd be talking about a Florida Building Code violation and those types of things. I'm going to put that aside for the purposes of where we are today, and just look at the evidence outside of how big it was, how tall it was. Even without any kind of building code violation, we're talking about a condition that we know from the evidence Mannheim knew about. Not just that they knew about it from the day or the weeks ahead, they knew that that condition was there in the condition that it was in at least a year. That's from the testimony from their own employees, and they didn't do anything to remedy it. Nothing. Now, there was some testimony about, well, in certain parts, you know, we do some filling of potholes, and some of our maintenance kind of do some refilling of potholes. But it was very clear that the maintenance personnel at Mannheim, that wasn't part of their job, or at least that's what the testimony was. They didn't level parking lots and things of that sort. That was something that Mannheim had to have someone come in and do. Well, they obviously didn't do it in that case. And so we have a situation where we're not talking about some remote area of the lot where Miss Evans or at that point had no business being at, you know, the vehicles were nowhere near what it was. She was literally walking on a parking lot that the products were on, i.e. the vehicles, towards the vehicles that they were going towards with her iPad, because she was going to take some pictures. And she tripped over this condition. The parking lot itself is their business floor. It is no different than walking through Walmart and having business floors throughout it. It's just not different than that for the purposes of this, because we know that Miss Evans was a business invitee there.
Well, a change in floor levels alone generally doesn't constitute a dangerous condition, right? So it's not like a pothole. There's a distinction under the law between those two things, right?
There are distinctions, correct, Your Honor, but the distinctions that I think the appellee is putting, it's mixing apples and oranges. We see through the law 2 different, I want to say criteria, but versus indoor versus outdoor. And what I would say is versus a personal residence, right? You see the cases that have been cited about a personal residence and someone's there for maybe a party or a get together. And then there are these height differences in an indoor residence of someone. The law says, look, there's indoor residence heights that are different, and we're not going to say that we're going to say those open and obvious. We're going to grant summary judgments based upon those, and they have. But we then shift to another part of the case where we're talking about business invitees. That is a different standard than what the courts look at when they're talking about internal residences, personal residences of people. And when we look at business invitees, they say, and this is throughout the case law, that is it open and obvious? It could be. Does open and obvious mean that now you have no duty of law either to warn or to maintain? No, that's not what it says.
Your duty to maintain is to maintain it in a reasonably safe condition.
Yes.
So, I mean, I think the argument is when it's open and obvious like this, it's not unreasonably safe. There's nothing you need to do. It's obvious.
I know it's
you don't need to level that pavement.
Sure, I know that's the argument that's there, but
what's wrong with that argument?
Well, and frankly, if that's the argument they can bring to a jury that is talking about the facts of the case, but that's not something that a summary judgment can be based upon, because for a trial court to be able to do that, the court would have to say that, or the trial court would have to weigh the evidence. I think that's what happened in this case, because the trial court would have to look at that condition and number one say, well, because of all the facts and circumstances around it, I think that's open and obvious to me.
Well, isn't the standard akin to the directed verdict standard? In other words, no reasonable jury could conclude.
It is. The federal standard is very akin to a directed verdict standard. But we also.
Could the trial judge say no reasonable jury could look at this and find that there was any failure to maintain, because this is open and obvious, it's not unreasonably dangerous?
I don't think I think from the facts of the case, if the facts were determined, all those different things without where it goes from being able to determine that as a matter of law, which is what directed verdict and what summary judgment is, there is, and I understand this is a very fine line.
Yeah, I'm
right?
not.
And yeah, certainly. Sure, and it's certainly, what is as a matter of law are the facts from this way versus this way, right? And I think that the cases that certainly this court has put forth, as well as other courts, talk about that somewhat. They talk about a situation where, I'll take Brookie, for example, the Brookie case out of the first district. There were facts in that case that talked about how this was open and obvious. One of those key facts was that the plaintiff saw it. So, the plaintiff saw the pallet. That was part of the facts of the case. Went by it once, came back, and tripped over it. So the first district in that case said it was open and obvious because the plaintiff saw it, right? Now, I'm not saying that in every single case, there's no case out there that says, well, the plaintiff has to be able to see it for us to be open and obvious. But there has to be facts within a case, I believe, for a court to be able to say as a matter of law, it's open and obvious. I don't think
that at some point it becomes sort of preposterous. I mean, some things are just open and obvious. And if you looked at it, or a judge looked at it, or anybody else looked at it, they'd say, that's open and obvious.
I mean, sure. I certainly recognize, if I'm coming into a parking lot and I see a 50-foot gaping hole that's in the ground because the sinkhole just, okay, that's open and obvious, right? I mean, so I think that
this block that she tripped over, it's pretty, it seems like it'd be pretty hard to miss.
Well, pretty hard to miss is not open and obvious, I think.
What if she walked right into the pole that was right next to the block? I mean, because That would be open and obvious, right? I mean, there's a big.
Well, there's no,
There's a 4-foot yellow pole.
I hear you, Your Honor, but there would be no duty to warn of that.
Well, but
There'd be no duty to maintain the pole. There's nothing wrong about the pole. I mean, so I think,
But as,
well, it's in the middle of a parking lot.
sure, but that would be like me running into here and saying,
but as a matter of law, a change in elevation is not a dangerous condition in and of itself, then how is that different from the pole?
well, I don't believe that is the law, Judge. That's why I'm trying to differentiate there. That change in elevation, there is no, that I'm aware of, that a change in elevation in a business setting is, that change of elevation is just automatically not something that a court can look at. There are cases that we've cited to, and actually frankly both sides have cited to, where, you know, there was a divot. There's one that there's a speed bump.
The divot, like when you, right after you step off the sidewalk, and so you
Sure.
can't see it, you've got your hands full of groceries, whatever. You know, these are people walking through a wide open parking lot. And in this particular, and it's right next to a pole, in this particular case, it was 11 a.m. on a bright sunny day.
Right.
What is it about this that makes the change in elevation in this case? What is that extra factor that makes it dangerous? Other than the fact that one person tripped over it.
Sure. The evidence that it makes it dangerous is that it is not something, the photographs though, as we look at them, you know, it's easy for us when we are looking at it, right? And we're focusing directly on it and looking down on it to see that. When you're walking across a parking lot and you're not looking, you're not scanning at a ground, I think that to accept that argument and what they're making and what you're saying, Judge, is that is it open and obvious if I'm looking at the ground and I'm seeing elevations through there? It could be. Is that something that I need to do as a business invitee? There's nothing that says I need to do that. And frankly, there's cases that say that isn't your duty. So
You have to pay attention to where you're going.
sure, there is a general duty that is certainly the cases have said that you have to be aware of your surroundings.
Because honestly, I am having a hard time with your argument, because it seems to me the logical conclusion is anytime somebody gets hurt, it becomes a jury question. Because if it's just a matter of contributory, as opposed to, you know what I'm talking about, yeah.
Compared.
Yeah, then it always goes to the jury and it can never be resolved on summary judgment. And I'm trying to figure out why, if we were to accept your point of view, that's not the logical conclusion that we would reach.
I think because, while we've been focusing on duty to warn, right? That's kind of where open and obvious really kind of files it. We're talking about duty to maintain too.
Yeah, I was gonna say, I don't think we're focusing on duty to warn at all. I think we're talking about a duty to maintain there's no question that a landowner has a duty to maintain their premises in a reasonably safe condition. So this is not a summary judgment that determined the landowner had no duty. What it determined is that there was no breach, which I think typically is a question of fact, but you're wanting to make it a question of fact all the time, is how I'm perceiving your argument. And I think the appellee is trying to argue, and I am inclined to agree, that at some point, whether or not that duty to maintain your premises in a reasonably safe condition, whether that duty was not breached as a matter of law, you can be reached by the trial court, and that can occur when a condition's open and obvious.
Sure.
It took me a long time to say that. I hope you understood it.
I think I do, Judge. And the way that I would answer, and hopefully I will be answering your question.
I don't know if it was a question.
Maybe a statement. Yeah, sure.
It's an opportunity to show
respond.
me the error of my ways.
Sure, I'll respond. So the way that I look at, and as we're looking at duty to maintain, the way that I look at duty to maintain is the duty to maintain has as its core, maintain its original condition.
No, reasonably safe condition.
Well, reasonably safe condition. It's the parking lot is a walking surface. Period. That's what it is. The parking lot for Manheim is for its customers to walk the surface to go to the vehicles and pick them up. All right. And so when we look at a duty to maintain in a reasonably safe condition, the having a part of the asphalt being higher, whether that's 1 inch, whether it's 5 inches, in a certain area, different than the other one, that is not in the condition. Number one, it's not a condition it's supposed to be in. There is no testimony, and I frankly can't think there would be, that part, that's, I guess I'll call it an island of asphalt, that's what it's supposed to be. There is nothing that says that's how it's supposed to be like. And so then I think what you're getting to, Judge, is that, well, now we have to figure out, well, what's reasonably safe? We know it's not in the condition it's supposed to be in.
And you know, you're at 15 minutes and
I'm
it's
sorry.
my fault because I keep asking you things, but I just want to let you know.
No, absolutely. And so I think when we kind of talked maybe back and talked about when does it come from a, question a judge can answer versus a jury, what's reasonably safe? We know, and there has been no argument that it is not the condition that it's supposed to be in. There's no evidence that that's how it's supposed to be. And so then we talk about, okay, well then, did they maintain it within a reasonably safe condition? We know that they knew it was there for a year. We know they didn't do anything about it. And so when we're talking about what's reasonably safe, I believe that's a jury question. The jury gets to decide what's reasonably safe. Just like a jury can decide whether someone's negligent for doing or not doing something. When we get to that point, that's where a jury comes in. I'll save the rest of my time for.
Thank you.
Thank you.
May it please the court. Steve Main on behalf of the appellee in this matter, Manheim Remarketing Inc. Your Honors, this is a straightforward trip and fall case, and the trial court absolutely got it right when it concluded that the condition that the appellant claims caused her to trip and fall was something that's so obvious, innocuous, and ordinary that it simply does not constitute an inherently or unreasonably dangerous condition as a matter of law. As the court has referenced, we've got photographs of the incident, of the condition, and those photographs obviously speak for themselves. Ms. Evans testified unequivocally that her view of the condition was not blocked or impeded in any way as she made her way through the parking lot. As the court noted, this happened in broad daylight, 11 a.m. in the morning. There is nothing in the record to suggest that there were any prior incidents or complaints with this particular condition, which goes to the point of whether or not it was something that was inherently or unreasonably dangerous. As my colleague also alluded to, there is also something which I think makes this case distinguishable from some of the other cases. And Your Honors, I will acknowledge, as the court is obviously aware, there's a vast body of case law on this open and obvious doctrine. Cases have been affirmed, summary judgments have been affirmed on appeal, summary judgments have been reversed on appeal. One of the distinguishing factors, I think, in a lot of those cases is that there is expert testimony, either by a human factors expert or a building code expert talking about a condition being unreasonably dangerous. We don't have that here. So what we have is the record. And I think the trial court, in looking at those photographs and considering all of the other evidence in the record, came to the right conclusion, applying the principles that this very court announced in the POV Simon Capital case, which is obviously referenced and discussed quite extensively in the brief. That was decided by this court back in July of 2023. And the key language from that court that I think is applicable to this appeal, Your Honors, is that it recognizes and holds that nonetheless, some conditions are so obvious and not inherently dangerous that they can be said as a matter of law not to constitute a dangerous condition. They will not give rise to liability due to the failure to maintain the premises in a reasonably safe condition. So these are all the terms and the concepts I think that the court was discussing with my colleague. And I think when you apply that principle to the record in this case, again, the conclusion reached by the trial court is the correct one. I want to reference, I think it was discussed briefly about the duty to warn versus the duty to maintain. the court has recognized that those duties are not mutually exclusive, and there can be cases, to follow up on your comment, Judge Black, that on the spectrum of what may constitute an unreasonably dangerous condition, that there's some conditions that are just so open and obvious that it would be preposterous for the court to conclude that it's somehow a jury question to decide whether or not presents a dangerous condition. I will also highlight, I suppose, for the court that this was not a designated pedestrian walkway, as was alluded to by my colleague. This was one section, one very small section, as part of a multi-acre parking lot where my client stores the inventory for its wholesale auto auction. And so as it relates to some of the scope of the duty to maintain, there's a couple of principles that are referenced in the answer brief that I want to highlight again for the court. The principle that a property owner is not required to take measures to avoid a danger in which the circumstances as known to it do not suggest is likely to result in injury. Again, when you look at the facts of this case, when you look at the record, I would submit that this is not something that Mannheim had any obligation, that the circumstances known to it would suggest to it that it needed to take some sort of remedial action or repair. Florida law also holds that a property owner is permitted to assume that those entering its premises will perceive conditions that are open and obvious to them upon the ordinary use of their senses. Once again, it's a very common sense principle, and I believe that principle is applicable to the facts here. Again, accentuated by the fact that there's nothing in the record that no other employee or invitee of Mannheim at any point had any issue or problem or complaint regarding this particular section that appellant maintains was an unreasonably dangerous condition. Lastly, the Florida law holds or recognizes that there are no premises safe enough to entirely foreclose the risk that a guest might injure himself during an inattentive moment. And as the court is aware, there's no obligation that a property owner is somehow the virtual insurer of any invitee who comes upon his property. So applying all of those principles. Oh, and lastly, I wanted to just bring to the court's attention as I was preparing for this argument today, in addition to the Kelly v. Sun Communities case, which incorporates a photograph of a section of sidewalk. It's a federal court opinion that includes a photograph, where the court basically reached the same conclusion that this condition as depicted in the photograph is not something that's so ordinary and innocuous. It's simply not something that's inherently or unreasonably dangerous. There was a recent opinion issued by the 5th DCA just this past October in the Jackson v. Florida Department of Transportation case, and I'll file a notice of supplemental authority following this argument today. But once again, that opinion out of the 5th DCA just a few months ago includes a photograph of a section of sidewalk, again, something that's a designated pedestrian walkway, and the court referenced that same language I just alluded to a few moments ago, that some conditions are simply so ordinary, open, and innocuous that they do not rise to the level of an inherently or unreasonably dangerous condition. So I believe that the sea change of the law in this case, and I know that appellant cited cases that favor his position, but in this particular situation, given the law, given the principles announced by the PO court just in 2023, this is a situation where the summary judgment entered by the trial court should be affirmed. Thank you. Unless the court has any questions.
Yeah.
So I'll begin with,
Just.
oh, I'm sorry.
Really,
That's fine.
were you, he hadn't filed a supplemental authority, so
No.
are you aware of that case at all that he just
I am.
discussed?
It's my case.
Oh, okay. I was gonna say, I could give you some kind of opportunity to respond.
I can judge,
Okay,
I mean,
don't want you to feel ambushed.
sure, no, and I appreciate these things happen. We find cases at the last minute, happened to me too. But the Jackson case, one of the big things in that case, Judge, was that I think it was the Department of Transportation, and this is one of the public sidewalks. So so we're talking about a different defendant. First of all, we're talking about a public defendant, which I recognize, the law treats differently, frankly, than business invitees and things. And part of that case was also that The expert testimony that was in that case deemed that sidewalk to be a walking path, but it wasn't attached to anything. So there was expert testimony that the court basically disallowed, and then the appellate court, the 5th district, said, we agree that the expert shouldn't allow it. But what I wanted to, and I certainly will give any other ones once the notice is done. What I did want to note is that I didn't hear anything from appellee that this was a safe condition, that it was that Mannheim didn't breach their duty to maintain in a reasonably safe condition, because has never been that argument in this case. The argument is that we know the condition is that, we know it's been there for a year, and we just didn't do anything about it, but we think it's open and obvious, and so that means we didn't have to do anything about it. That is a very dangerous precedent for this court to put into action. And I would cite back to Bryant versus Lucky Stores from this court, talking about, in that case, if the court will remember, it was a sidewalk, it was a speed bump, they stepped on the speed bump. There was nothing wrong with the speed bump. Just stepped onto a speed bump. Plaintiff claimed that the sidewalk and the speed bump were unsafely designed and that the defendants breached their duty in that case. The trial court entered summary judgment, but this court reversed, holding that the trial court failed to consider all the facts and circumstances. And specific, Judge Kelly, what we were talking about, this court concluded that whether the speed bump was unsafe, created questions of fact to be resolved by the jury. And so this court has specifically said that when we're talking about whether something's unsafe, which goes into whether you've maintained in a reasonably safe condition, that is a jury question. And that's what we have in this case. So I would ask this court to reverse the decision. Thank you.
Hey, thank you. Thank you both. And that concludes Ms. Arthur's docket. We have one more case, but we're going to do that remotely. Thank you all.
All rise.
Oh, good. I didn't think
Get used to it.
Yeah, yeah. I need to practice with them.
I didn't mean, I wasn't meant to ask you, did you go through the wrong door? Is that why, like?
I don't know, no, because I did badge through it and I had already been through. I think it's like something in the hardware that needs to be adjusted, because I was sitting here and unless somebody touched it on the other side.
Oh, okay.
I was alarmed. This should be.
Yeah, I saw you come through and it was fine. All of a sudden it just went off. So.
Yeah, after I sat down, it started going off. So if I get somebody to look.
You didn't like it.
Oh, thank you. You too.
Oh, is that an umbrella?
Okay, I'll grab it.
Can I ask a question?
Oh, I'm sorry. I thought everyone had left. What now? What do you need?
Are you one of the judges?
No, I'm the marshal.
That's what I was thinking. You were here at the desk?
Yes.
Okay. And do they do court reporting in here?
No, the appellate court is not a court of record. So we're reviewing the lower court record. We don't make our own. So we do record it just for public interest.
When will anybody know, well, when will the public know how the judges decided?
Our court's opinions are published on the website. So they mail their opinions to the parties on the same day or the next day after they mail them. They publish them on our website. So if you go to our website, You'll find a location, a site that says, opinions, and you can see them there.
Just the website would be.
Oh.
exit out,
leave.
Yeah, it's, www.2dca.floridacourts.org.
So this is Pasco and Pinellas and Hillsborough.
DeSoto, Manatee, and, Sarasota.
Wow. Big area.
Yeah.
And only 4 or 5 cases. That's amazing.
Yes. We can do this a couple times a week, but I have a judge waiting for this paper here, so thank you.
Yes.
There's the camera. Picture. What else?
Judge Kelly has to get her.
How do I get a bigger screen?
That, where you were?
This one?
Yeah. This, yeah, it's
Is
kind of,
that?
well, yeah, try that one. It's kind of odd. I know, go back to that. I don't know why that box pops up. Not that one, the one next to it now. Hit that. Hit that. And hit that. There.
Good morning. This court remains in session.
Hello, everyone. We're here for our last case on today's docket. Florida Association of Christian Child Caring Agencies versus the New York Times. Counsel, when you're ready. We're ready when you are, Mr. Bailey.
Thank you, Your Honors. Good morning. May it please the court, Jeremy Bailey on behalf of, we call it FACA, just to save everybody a little bit of time. Can I reserve 5 minutes for rebuttal? So FACA is a private nonprofit entity that exists to assist its agencies, its member agencies, with fulfilling their scriptural mandate within a specific statutory exemption in 409.176. The trial court's error here was converting that exemption into the total, complete, all-encompassing delegation that's required in order to convert a private entity into an agency under the Public Records Act. And there's 2 points I want to make on this. First, DCF still maintains such not only exclusive authority for non-FACA member agencies, but significant oversight and regulatory approval over FACA member agencies, that there cannot be a total and complete delegation. And second, even if this court were to find that there is a delegation here, we believe that the trial court went far too broad and just kind of throwing open the doors on FACA without going through the analysis of which individual kind of components of FACA would be subject to that delegation test. Because as this court's precedents note, it's not an all or nothing proposition. There has to be analysis on a more granular level. On that first point, so typically courts reviewing whether or not a private entity is subject to the Public Records Act, they apply the Schwab test, right? They go through all the factors, there's 9 of them. There's a holistic analysis about what a private entity is doing and whether or not they're subject, whether their activities rise to the level of being an agency. But here, both the New York Times and its pleadings and its motion for summary judgment specifically abandoned that argument. They said they wanted to go solely forward on the delegation tests. And so that's what the trial court did. But that's a problem here because the delegation test isn't a parallel, you can either satisfy Schwab or the delegation. It's a high bar. I mean, and that's what the court in Economic Development, or the 5th District, Economic Development Commission versus Ellis said, is that the error in that case was not applying Schwab, right? The court jumped straight like the court did here to the delegation test. And it is a really high bar to show that there's been a total, complete, compelling, complete assumption of a governmental authority. And that's what we have in these cases of Stanfield, the BNS case, Prison Health. In Stanfield, the Salvation Army took over all of the misdemeanor probation services for the county. It was a total, complete delegation of that clear governmental authority. In BNS, similarly, it was a total, complete delegation of the county engineering role, right? Again, total, complete, they did everything. There was no other actors in the space. Prison Health, right? Same. They were the only healthcare provider for federal and state prisoners in the county prison system. It was a total, complete delegation of that authority. We don't have that here. We don't have a total, complete, clear and compelling delegation of authority. Because remember, what we have here is we have an exemption for entities that are choosing to operate within a specific religious mission, right? And so when you look at the statutory exemption, it's not a dual licensing scheme like the trial court held. In order to establish your eligibility for this exemption, to your own financial detriment, you have to refuse state and federal funding, number one. Number two, you have to be a religious entity. And the reason that the legislature put this exemption here is because there would be issues if the state said that they're going to treat religious and non-religious entities alike. As you look at the deposition testimony of Mr. Higgins, and FACA member agencies are different than child caring agencies that are regulated by DCF. They have a religious mission. They have a mission statement that the agencies have to adopt. They have to agree to.
But there's no dispute that they have to be registered with one or the other, correct?
Correct. Yeah, they can be exempted from the DCF regulation if they are registered with FACA. That's correct. But even that registration itself in 409176, it says that the FACA registration process is overseen by the department. DCF isn't taking a hands-off approach and saying either you register with us and we provide oversight, or you register with them, in which case we're hands-off. In the registration process through FACA, not only are the guidelines required to be submitted to FACA or by FACA to DCF, DCF has to approve those initial guidelines. DCF has to approve any changes to those initial guidelines. And then we listed the laundry list of statutory provisions in 409176 at sub 7, sub 9, 10A, 10B, 10C, 11A, 11D, 11E, where the department says, regardless of if you're registered with FACA or through this exemption, we are still going to exercise our supervisory oversight over FACA and the member agencies. This is not a total, complete delegation of authority that you would have in order to fit into that exception from the Schwab test. I think the proof is in the pudding when you look at the type of agencies that Mr. Higgins talked about are members of FACA, because he was the only witness in this case, right? FACA posts on their website all the maternity homes. It's all out there for the public. None of those maternity homes were deposed. Nobody, the New York Times didn't do any third-party discovery to any of those. Mr. Higgins presented unrebutted testimony that the maternity homes that they work with at this point work with adult women, and there's no minors involved in the process that would be subject to the DCF oversight. But what he explained is that these agencies are going out into the community and working with adult pregnant women, right, as maternity homes, and they have a strict mission statement, code of conduct, religious beliefs, all of these things that make them very unique from a DCF run facility or DCF regulated facility. But he explained that doesn't mean that DCF isn't involved, that if there's ever an issue, it's not, well, we got to call FACA and FACA will handle it. No, it's we got to call the department. We got to call DCF because DCF still maintains primary authority over all of these instances throughout the legislative scheme. So for the trial court to say, well, just because there's a registration, you can register either with FACA or DCF, it's a complete and total delegation.
But FACA is not registering parties on behalf of DCF. They're not providing a service to DCF. DCF has delegated to FACA the ability to serve as the registration entity for these agencies, correct?
That small sliver, yes, Your Honor. In just the registration component, none of the remainder of the oversight still remains with DCF, and that's
because you're talking about a complete delegation in terms of the quanta of activities that are assigned to the other entity. But this is a total delegation of the registration requirement, right? It has to be registered with either one or the other. So, I mean, aren't we you're saying, well, that's not a total delegation, a complete delegation, because DCF still maintains oversight. But I think the distinction is this is not like DCF didn't hire FACA to register these agencies on behalf of DCF. It is a total delegation of this finite requirement, but that makes it no less a total delegation.
Well, I will say two things, Your Honor. One is it has to be an exemption because part of the FACA process is that the agencies that register with it have to agree to abide by a certain religious doctrine, right? DCF obviously couldn't do that. And in fact, DCF couldn't permit homes to be a shelter, for instance, right? Be a shelter home if they said, if you're going to come into our home, you have to abide by our religious doctrine, right? There is tension there because the FACA exists to do that registration, just like you're talking about, do that registration piece, just that one small piece, which allows them to keep their, the religious scriptural mandate as a component of their operation. But what the case law says, in order to say that entity has become an agency for purposes of the Public Records Act, it's not just whether they're doing one small piece. That's what the Fifth District said in the economic development case. They were reviewing applications for tax credits. They were working with local businesses. They even had a contract with the county, and they received county money. And the court said, still not a total and complete delegation. You got to go to the Schwab factors. The total and complete delegation is when you take a governmental function, right? The probation, the prison health services, the county engineering. It's that entirety of the function and giving all of it to a private entity, not just the small sliver of registration.
So you're saying that the state would basically have to abdicate its responsibility to provide for child welfare for this to be a delegation, a total and complete delegation of authority to FACA?
Not abdicate, but they would have to delegate it, right? So if the state says, we are going to give you certain responsibilities to do in the process, but we're going to maintain supervisory control, then that doesn't qualify as a total complete delegation. And it's important because what we've argued all along is that this case should have been resolved under the Schwab factors, right? We're not here saying that, that FACA could never be considered in any of its activities to be a public agency. What we're saying is that the trial court took a 30,000-foot view and said, simply because you do the registration piece for certain child caring agencies that are exempt from the statute, then everything FACA does is subject to the Public Records Act. That's a dramatic step. That's not in line with the clear and compelling case law. Now, if the court had gone through the Schwab factors and said, well, you do this thing and this thing, and have this type of government activity, and you have this level of funding, you have, this type of activity is typically and traditionally a government function, it might be a different analysis. But here, it's just that sliver of piece, the registration piece, where the DCF says, because of your religious nature, because of the religious requirements that you have for your religious agencies, you're going to do that piece, and we're going to maintain control, and we're going to keep an eye on every single child caring agency in the state of Florida. It's that small religious registration piece can't be a total and complete delegation because it's just a small piece of the puzzle. Because remember, when you're dealing with these child caring agencies, it's not the upfront registration that matters. It's the ongoing, who's investigating instances and allegations of suspected abuse, DCF. Who's making sure that and this is all straight from 409-176, right? That who is making sure that an entity is not trying to take care of a child that's above its capacity. Well, that's sub 7. It says the department, DCF, not FACA. They're the ones that have to be made aware of that. All throughout the statutory scheme, the legislature gave FACA a small piece within that religious exemption, but kept the remainder of the oversight with DCF. And on those facts, that doesn't satisfy the total and complete delegation. Now, again, may satisfy Schwab, but the New York Times and the trial court both said, we're not doing Schwab, we're only doing the delegation test. And that's why on these facts, on the delegation test, it doesn't fit. And the kind of the second half of the analysis is that even if
has there been a situation where a child care entity would object and say, well, look, if the New York Times is going to stay involved, then we don't want to be involved.
Potentially, right. I mean, I guess, when you have, if I understand your question correctly, the trial court didn't just say, for these reports or for this particular small activity, you're subject to the Public Records Act. It had a much broader approach and said, you're subject to the Public Records Act for everything because you do the registration piece. And the same argument would apply to the Open Meetings Act. Why would FACA's board meetings not be open to the public? Why would they not have to, let members of the public come into their religious, Christian focused meetings, so that That's the problem with going to the delegation test and just saying we have this piece of the puzzle, therefore we're going to call it a delegation, instead of going to the Schwab test and looking at what specific act is the entity doing, and is that specific act subject to the Public Records Act? To Judge Rossignocum's point, the registration piece, right? The trial court could have applied the Schwab factors and said that registration piece is subject to the Public Records Act because that is something that that has been delegated to FACA by the legislature. But that wasn't what the trial court did. The trial court said because of that small sliver, we're just going to throw the whole thing open to the Public Records Act. And that, on my second point, that's why I think at the very minimum, there has to be a reversal to go back and look at the actual records of the individual maternity homes that are being requested. Because Mr. Higgins, we went through all the maternity homes in his deposition that are currently registered, and that there was no evidence presented that any single one of those maternity homes is at this time or in a non-historical time period taking care of children. And that's what the statute says. In order to be required to even get a license, to even have to go through the registration process, you have to be providing 24-hour childcare services, not to mom and baby, but to the actual child themselves. So,
Mr. Bailey, I just want to let you know, I'm sorry to interrupt. You're at 15 minutes.
thank you, Your Honor. I'll finish with this sentence. That what the trial court did was say, again, that throwing open the doors, but then even took it a step further and said all of the records are subject to the Public Records Act. And what this court said in the Sarasota Herald Tribune case, Judge Altenburg's opinion talked about in the very last paragraph about even if there are some things that are subject to the Public Records Act, we got to go back and look at what actual activities are being delegated. And if it's not a delegated activity, it's not subject to the Public Records Act, and those particular documents would not be subject to being produced. So I'll reserve the remainder of my time for rebuttal. Thank you.
Thank you.
Thank you. May it please the court, Giselle Geronis on behalf of the Appellees, the New York Times Company, and Laurel Morrill. Despite standing in DCF's shoes for the purposes of certifying and inspecting certain residential child caring agencies, FACA seeks to avoid the Public Records Act. And to justify that position, it's claiming that because it doesn't regulate all the residential child caring agencies in the state, it's not performing a governmental function. Alternatively, it argues that the records at issue should not be disclosed because there are currently no minor children at those agencies. But these arguments were properly rejected by the lower court. And as the trial court found, when FACA acts pursuant to its delegated statutory authority, it's an agency subject to the Public Records Act, and it must turn over the requested inspection reports at issue here, which are public records. And just as a initial point, I'd like to say that the trial court order is limited. At issue are, as I mentioned, the public records requests for inspection reports of these maternity homes, which are certified by FACA. And so what the court is looking at is when FACA is or acting pursuant to this delegated statutory authority, it is an agency. And those records that are created while exercising that statutory authority are public records. We're certainly not taking the position that all of FACA's records are public, and I also don't believe that is what the trial court order says. So turning first to the issue of whether FACA is an agency under the Act, a private entity is considered an agency when the legislator delegates to it a governmental function. And the focus is on function, or who is performing the government's work. And so here, there's no dispute that licensing and regulatory oversight of these residential child caring agencies is a core state function. The legislator tasked DCF with establishing licensing requirements for these agencies. And before one of these agencies can accept custody of a child, it must obtain a license from DCF. And that process requires DCF to inspect those facilities at the time of licensing, and then again at least once a year. It also requires DCF to issue health, safety, personnel standards for those facilities. And if an agency fails to meet those standards, DCF can deny or revoke a license. The legislator created an alternative regulatory option for agencies that are religiously affiliated and receive no government funds. Those agencies can opt to be certified by FACA. So religious affiliated agencies seeking the ability to care for children have two options in the state. They can be licensed by DCF or certified by FACA. And regardless of the option they choose, an inspection of the facility is required. And the legislator, in delegating that function, granted FACA the authority to determine whether these agencies meet the legal standards for providing care to vulnerable children. That includes obviously the certification, but also creating standards that are in substantial compliance with DCF standards, inspecting those facilities, enforcing compliance, and revoking certification if an agency is non-compliant, which would then mean that that agency would not be able to legally accept a child in its custody. And all of that is the same regulatory function that DCF is performing under 409-175. So absent that delegation, those duties would have to be performed by DCF. When FACA is exercising that delegated authority, it's acting on behalf of the state and is subject to the act. I know FACA tries to word this as an exemption rather than a delegation, but the statute doesn't remove state oversight for these religious residential child caring agencies. It simply substituted FACA for DCF, and that substitution is a delegation. The focus again is on the function that's being performed, not whether the entity has a religious status or not. There's no religious carve out in Chapter 119 once a governmental function is delegated. And when a private organization, religious or not, is performing a governmental function on behalf of the state, it's treated as an agency under the Public Records Act. FACA also argues that because it doesn't oversee all of the residential child caring agencies, it cannot be subject to the act. And that's getting a little bit to the argument about whether there's a complete delegation. But it doesn't matter whether DCF retains some oversight or whether it has concurrent authority, because delegation under the law does not require abdication. The test is not whether all of DCF's responsibilities are transferred to FACA, but whether FACA is performing a public function. And the answer is yes. Once FACA inspects and certifies a maternity home pursuant to its statutory authority, it's performing that public function. I think the Putnam case here is instructive. It makes clear that a delegation does not require the state to relinquish all authority. And in that case, we were dealing with a statute like we are here, which gave the Humane Society the authority to investigate and enforce animal cruelty laws, including seizing animals. And the Humane Society acted independently, even though law enforcement and other county officials retained authority to conduct the same exact activities. And the 5th DCA there held that the society was an agency despite that concurrent governmental authority. So here too, the legislator vested FACA with regulatory authority, and its certification determines whether a facility may lawfully care for a child. It doesn't matter if DCF can also do that for other residential entities, or whether it has some supervisory role. That function is still being delegated to FACA. And if the outcome were different, that would mean that the state could shift a core regulatory function to a private entity and erase all public accountability. And it would render Article 1, Section 24 of the Florida Constitution and Chapter 119 optional. So in short, when FACA is inspecting and certifying agencies pursuant to 409-176, it acts on behalf of the state, and it's subject to the Public Records Act. So the trial court ruling on that point should be affirmed. Moving on to the issue about whether the specific records requested here are public record. The question of whether a document is or is not public centers on why the record was created. And any records created while performing a delegated governmental function are public. So the inspection reports that were requested here and we're talking about were created while FACA was exercising that statutory authority to certify the maternity homes in question. In other words, they exist because of FACA's statutory authority. Had the maternity homes opted to be licensed under DCF, the inspection reports would undoubtedly be public. And the results should be no different just because FACA is the one conducting the inspection instead of DCF. FACA argues that disclosure of the records should be limited to only those maternity homes that are currently providing care to minors, but that issue is irrelevant. FACA cannot choose to toggle public record status based on a home's population at any given time. That would mean that the same inspection report is public on a day when a minor is present, but private on a day when it's not. And such a finding would contravene public policy. But it also doesn't really make sense, right? Because if a DCF licensed home stopped caring for a child, the inspection reports for that home would still be public. So there shouldn't be a difference just because it happens to be FACA certified rather than DCF licensed. The purpose of that certification is to approve a facility's ability to care for a child. And in fact, FACA's director acknowledged this in his deposition when he said that facilities that don't currently have minors but want to keep that door open seek certification from FACA. FACA also claims that, because these agents voluntarily registered, those records shouldn't be subject to public disclosure. But the voluntary participation nature of it doesn't change the nature of the function that FACA is conducting when it's creating these records. FACA is still acting pursuant to its statutory authority when it's conducting these inspections, when it's creating these reports. And so when those inspection reports are created while FACA is exercising this delegated statutory authority, the trial court was correct in concluding that those reports are public and must be disclosed. I do want to acknowledge that Mr. Bailey mentioned, where is the limit, right? And there is a limit. The limit is the records FACA creates while it's exercising this delegated authority. Any records separate from that, separate from those functions would remain private. I'm not sure what else FACA does, but to the extent it is conducting other activities or functions separate from that statutorily delegated authority, those records would remain public. And the trial court already limited the ruling to the reports at issue, the reports that were requested, which were created while exercising this authority. So there's no need to draw the line. There's no need to remand in this case because the ruling is limited to that finding. If I could just briefly address the issue with Schwab. Schwab only applies where, absent delegation, a court needs to determine whether a state contractor or a private entity is involved in performing a governmental task sufficient enough to be deemed an agency under the Public Records Act. But the trial court here correctly disregarded Schwab because, as I mentioned, delegation is explicit from the language in the statute. And so there was no need, there's no error to have conducted the Schwab factors because we're dealing here with a delegation that is explicit from the language on the statute. And even so, I believe the outcome would have been the same under Schwab. And I'm happy to walk through those factors if the court wishes to hear more on that. But again, our position is that those factors did not need to be considered because once there's been a delegation that's explicit from the statute, there's no further analysis needed. So, the case is really not complicated. Religious residential child caring agencies that want the ability to care for minors have two options. They can pursue a license through DCF or they can seek certification through FACA. And under either scenario, an inspection of the facility, amongst other things, is required before the facility can ever care for children. And those inspection reports are public records. So when FACA certifies a residential child caring agency, like a maternity home, it exercises its statutorily delegated authority to inspect and certify those agencies. The Times made a public records request for specific inspection reports of maternity homes certified by FACA pursuant to the statute. And FACA refused to provide those records, and that refusal violated the Public Records Act. So despite the many arguments that FACA makes, it really is that simple. The question is whether 409176 delegates a function that would otherwise be under the purview of DCF, and if so, whether those records are public. And the answer to both of those questions is yes. Any other arguments are red herrings. It does not matter that DCF exercises concurrent authority and licenses other residential child caring agencies. It does not matter whether or when a child is present. There's no First Amendment consideration, and the court did not need to consider the Schwab factors given the clear delegation. So unless the court has questions, we believe the order should be affirmed.
Thank you.
May it please the court, just a couple brief points on rebuttal. I want to say one thing about the concurrent authority, and I think that if the court goes back through the language in the cases that we've cited in our brief, the BNS case, the case I talked about, that concurrent authority does pose a problem to the clear and complete delegation argument. I think that when you have concurrent authority, you no longer have a complete delegation. I mean, that just is the nature of the beast. More importantly, though, I would say that the issue with the subjecting all of the maternity homes to the Public Records Act is that Mr. Higgins explained that a lot of these homes, or at least the ones he named, register with FACA for the credibility it brings, not because they're statutorily required to be registered, right? They don't take care of children, they don't take care of minors, they help adult women. They're not required to register with FACA, they're not required to register with DCA. They have no licensing requirements from the state of Florida, and they choose FACA for the benefits of working with other member agencies. And so what the trial court said is that because even though they have no statutory requirement to register, because they voluntarily registered, that makes them subject to the Public Record Act. And that just doesn't make sense on a delegation argument because there couldn't be delegated statutory authority when they had no legal obligation in the first place to register. And that's why we think that the trial court's order was at the very least overbroad, and those homes should be excluded from the scope of the order. We ask the court reverse. Thank you.
Thank you both. That concludes today's oral argument session, and court is adjourned.
Thank you.